Yes, they rob I, sold I to the merchant ship. Minutes before they took I from the bottomless pit.
Okay. Is there anything else that you want to say about that?
I don't think so, because if you can't, if nothing nice, you should say nothing at all. I'm appealing, and also now with a felony, then I can't be a candidate, so that's up to the Supreme Court to handle this felony over something that is civil infraction. They have city ordinances, so that's the thing that's what I'm appealing to. They can give some people city ordinances for this, $150 fine, no probation, no jail time, no nothing. So if if it was your son or if it was his relative or somebody that was hooked up in this system right here, they'd only get $150 fine for this marijuana that you're giving these 140 days. It's just totally ridiculous, but you're not going to believe that, so that's why I'm before the Supreme Court, and if I have to sit in jail and I can't keep defending myself and lose, then I'll just, whatever, when I get out, I'll keep trying to make this right for everybody.
Is there any reason why sentence should not be pronounced upon you? From you, it's up to you, but I think the reason that a sentence shouldn't be put upon me, because I do have a stay of sentence that is awaiting the decision of the Supreme Court right now. I motion for a stay of the sentence in the Supreme Court. As to count 1 and count 4, we look at the seriousness of the crime, and these are not particularly serious crimes. Mr. Driessen possessed a small quantity of marijuana. He possessed drug paraphernalia. There's no indication in the record that it was for anything other than personal use. There's no indication in the record that he was under the influence of the marijuana at the time he operated a motor vehicle. So it's not like this marijuana is in the marketplace. There's no indication that it is up for sale. It's not a particularly large quantity, and there's no indication that this was influencing Mr. Driessen's driving. So to start with, it's a relatively low-impact crime. The next thing we look at is the defendant's character. Throughout the proceedings, Mr. Driessen has challenged well-settled law suggesting that the law forbidding possession of marijuana is unconstitutional. There's no suggestion here of any remorse or repentance when it comes to the drug charges. And I think, therefore, Mr. Driessen is at least an intermediate, if not a high risk, to reoffend. We look at the need to protect the public. I don't want to make too much of the variety and number of the drug convictions on Mr. Driessen's record, but I also don't want to make too little of it. Perhaps if Mr. Driessen is disobeying the law in the privacy of his own home, he's not much of a danger to the public. But to the extent that the use of chemicals, whether it's alcohol, marijuana, or something else, impairs his judgment, and under such impaired judgment, he gets behind the wheel of the car, there is a danger there. So I think we've got an intermediate to high risk period of time and some danger to public. So it's going to be jail time as the counts 1 and 4. I think that he defends prior record. 100 days incarceration on count 1 and 30 days incarceration on count 4 are appropriate. Mr. Driessen cannot violate the law with impunity. There's a consequence if he's going to break the law. There's a consequence for doing so. So accordingly, on count 1 is the judgment sentence of the court. The defendant is incarcerated for 100 days in the county jail. He is to provide a DNA specimen. Now, in this case, I don't know that a DNA surcharge is necessary. It's not mandatorily necessary, and I don't know that this is the type of case that is often resolved by DNA analysis. Nor do I see anything in Mr. Driessen's record that suggests that he's been involved in cases that are ordinarily solved by DNA analysis, and plainly not going to impose the $250 DNA surcharge. Nor am I going to impose community service. Again, that's something I probably $50 fine on count 1. On count 4 is to be incarcerated for 30 days in the county jail and pay a fine of $224. All of this incarceration runs consecutively, so it's a total of 140 days. Mr. Driessen is granted credit for time served as computed by the Sheriff's Department. He is granted work release privileges during the hours and under the conditions set by the Sheriff's Department. He will receive good time unless the bad conduct he loses good time. Mr. Driessen, you to contact the Sawyer County Jail within 10 days to set up the exact date and time to start serving the sentence. You are to start serving the sentence no later than 60 days from the date. Any contraband seized in this case is already forfeited. As a convicted felon, you may not legally possess a firearm. Okay. Possession of a firearm by a felon is a Class G felony in Wisconsin, and a Class G felony is punishable by a fine not to exceed $25,000 and imprisonment not to exceed 10 years of court. As a convicted felon, you may not legally vote until your civil rights are restored. And that will happen when you have completed the felony portion of the sentence. So, for instance, I would say on count 1, you need to give notice of intent to pursue post-conviction relief to this court and the district attorney's office within the next 20 years. Understand your right in that regard.
So do I already have an appeal filed, Your Honor, and I would like copies because there's they can give you on permission, they can give you appeal. So I'm going on permission, and I want is this the final judgment of this case today?
Yes, so the judgment of conviction should be the final appealable order.
Yes, and I want a copy of that today somehow from the court. Like, hopefully before I leave the court, I hope I can get a copy of that with a little stamp on it from you so I can keep at it.
Oh, won't you help me to sing these songs of freedom? 'Cause all I ever had